Good morning. Namaste. Thank you for joining participants. This is our 54th episode of AAA Weekly Webinar Series. The subject continues to be the same: SEBI and stock exchanges compliances for the companies under IBC. There are many questions that we have in mind, and we have today two experts with us. One is Advocate Sumit Kochar, who is the partner of
Dolce Vita Trust.
Dolce Vita Trustees.
Correct.
And also we have Shivam Gera, who is an associate, senior associate with the same company, Dolce Vita Trustees. Ankit, as usually, he actually is doing a big job of observing, seeking questions, and also kind of adding comments wherever he feels that the direction which is coming from the audience needs to be reset. So he will immediately stop us wherever he is getting questions from the audience. Let me share my screen, but yes, in the last webinar part 1, there was a unique thing that I was in a train, whereas Sumit Kochar was in fact on Mata Vaishno Devi, and Shivam was in his own office, and Ankit was in his own office. So that was the time when we conducted. We don't want to change this 11 o'clock time every Saturday for a weekly webinar series of AAA Group. So Sumitji, I think I'm just sharing this screen. So we are not really depending much on the screen because this was mostly a repetition of some of the. But basically there are a few things that I would like to say in this regard. That this is what is a list of various circulars and the amendments to SEBI LODR regulations. LODR means listing obligations and disclosure requirement, and most of the SEBI compliances are built in LODR regulations. So the first was, it was in the regulation was in 2018, and that was primarily focusing on the disclosure requirement regarding any company which goes into CIRP and the obligations of the RP to disclose certain things. That was focused. Then this there was another circular which was primarily applicable to the RBI circular for intercreditor agreement, where the resolutions were found based on the intercreditor agreement of the total scheme introduced by the RBI. Then again, in January 8th, 2021, again LODR amendment was, and that was enhancing the disclosure requirement. And later on, then now we have the kind of the obligations guidance note also. The guidance note, which is actually June 7, 2022, I would actually request Sumit to focus on this guidance note, because this is a very, very kind of comprehensive guidance note where all the earlier amendments and the earlier circulars have actually been captured. So then, before even we go ahead with the kind of various amendments or circulars, so when we saw the various disclosure requirements, then we saw that what are the total disclosure requirements, and I will just see in case I can read all the 16 disclosure requirements, which are the responsibility of the interim resolution professional or resolution professional whenever a company comes under insolvency, means corporate insolvency resolution process. So whenever if filing of application by the corporate applicant for initiating CIRP, also specifying the amount of default. So this is not applicable to any application, but this is applicable to in case the application is filed by the corporate applicant. Now the corporate applicant is defined under IBC. It can be filed by the CFO of the company, it can be filed by the director of the company, or it can be filed by even the corporate debtor itself. So that is what is the definition of corporate applicant. So this particular first line is applicable only whenever an application is filed by the corporate applicant and not by the third parties. Next. Filing of application by financial creditors for initiating CIRP against the corporate debtor, also specifying the amount of default. This is again a requirement when the financial creditors file an application initiating CIRP, again the SEBI stock exchanges has to be informed. Next, admission of application by the tribunal along with the amount of default or rejection or withdrawal as applicable. So there are three things within the one line. One, that there is an admission of section 7 or section 9 or section 10 application by NCLT. Second, that whatever application was filed by the corporate debtor, corporate applicant, or by the financial creditor, that has been rejected. However, the section 9 applications, rejection of section 9 applications are not mentioned here. However, admittance of section 9 application actually would be covered. Admittance of section 9 application would be covered, whereas the filing is only covered for section 10 and section 7, and that is only financial creditors. Coming next, public announcement made pursuant to order passed by the tribunal under section 13 of the Insolvency Code, that has to be informed that the company's insolvency CIRP has started and the public announcement has been made. List of creditors as required to be displayed by the corporate debtor under regulation 13.2, because whatever list of creditors that we display to IBBI website and also on the website of the corporate debtor, that also has to be disclosed to the SEBI and stock exchange. Next, appointment replacement of the resolution professional is also one of the requirements for disclosure and informing, and prior or post facto intimation of meetings of the committee of creditors. Now, like in case we see, in fact, I was seeing, in fact, there may be about 50 times that during the CIRP period, there has to be some information or some disclosure required for the stock exchanges or the SEBI. Then is whenever there is a committee of creditors meeting, prior or post facto intimation, it has to be given. Brief particulars of invitation of resolution plans under section 25, subsection 2, clause H of the IBC in the form specified, like form G. So that form G has to be again disclosed to the SEBI and the stock exchange requirements. Number of resolution plans received by the resolution professional, that also has to be disclosed. Filing of resolution plan with the tribunal, like after the resolution plan is approved and it is submitted to NCLT for approval, that has to be informed. Then comes the salient features not involving commercial secrets of the resolution plan approved by the tribunal in such form as may be specified. Now, what are the salient features? Salient features which I have read so far, and I will seek the indulgence of Advocate Sumit Kochar. What I understand is that whenever there is any change in the capital structure of the company, whenever there is any change in the rights of the shareholders, whenever any change in the reduction of the capital, extinguishment of the shares, and the entire capital structure, that has to be informed. These are the salient features. And also, whether it's a partial resolution plan or it's a full resolution plan, that also is very, very important. Then it is specific features and details of the resolution plan as approved by the adjudicating authority under IBC, not involving questions, that we've already seen. And then pre and post net worth of the company, that is also supposed to be seen, because see, this is what is a capital structure. Whenever we prepare a resolution plan, it is a very, very important part of the resolution plan to provide a proposed capital structure. Because when we provide proposed capital structure, then only we would come to know whether the public shareholders are reduced to 5% or not, whether we are compliant to that particular condition or not, whether the company will continue to be a listing company or not, whether the resolution applicant is applying for delisting of the company or not. So these are very, very important information. Then is the details of the assets of the company post CIRP. That means whatever has been excluded from the resolution plan, from the RFRP. That has to be very, very specific, because why we are asking for the assets post approval of the resolution plan, post CIRP, because some of the assets might have been distributed, some of the assets might have been kept. I mean, now there are cases where some of the assets even will go for dissolution or liquidation. Details of the security continuing to be imposed on the company's assets. Securities continuing to be imposed on the company's assets. I couldn't understand this. Any other material liabilities imposed on the company? Yes, that is information. Pre and post shareholding pattern assuming 100% conversion of convertible securities. It has to be informed. These are the like particulars or fact, the very, very salient features of the resolution plan. Details of funds infused in the company, creditors paid off, additional liability on the incoming investors due to transactions, source of such funding, impact on investors, revised PE ratio, return on net worth ratios, etc. Names of the new promoters, key managerial personnel, if any, in the past experience in the business or employment in case where the promoters are companies, brief description of the business strategy, approval of resolution plan by the tribunal or rejection. So this is another significant event. Proposed steps to be taken by the incoming investor acquirer for achieving the minimum public shareholding. Quarterly disclosure of status of achieving the minimum public shareholding. The details as to the delisting plans, if any, approved in the resolution plan. So these are very, very important disclosures during the CIRP. So therefore, what I said, like this is important that we, all insolvency professionals must understand, that these are the requirements, and listing of a company is a very, very big asset. If a company is a listed company, it's a very big asset. And in fact, Ruchi Soya has been a unique example in India in insolvency regime, that Ruchi Soya has actually got the successful resolution applicant of Ruchi Soya has gained only because this company was listed. It continued to be listed, and immediately after the resolution plan was approved, the existing shareholders in fact start seeing gain in their shareholding, even if reduced value. Finally, they are very happy that it has been taken over by an efficient promoter, and the value of their shares, even after reduction, has again reached back to a very big peak. Here I will seek indulgence of Sumitji, because I'm in the meantime, I'm just searching through the various, what is the relevant PPT. But then I think I need your indulgence, and the questions that I asked you. The very, very first question is, and see, have you any idea like how many companies are actually being traded when the company is, when the CIRP order is passed? You are mute, Sumitji.
I didn't get the question, so can you say that again?
So, see, like as per your understanding so far, like how many are the companies in India so far which were actually being traded as on the date of commencement of CIRP? Like Ruchi Soya is one example. I believe many companies, or it was only a few companies which actually were being traded on the stock exchange as on the commencement of CIRP.
So there are many companies, as in off the cuff, I won't be able to give a number to that, but I can confirm that there are many companies which are being traded. For example, you can take example of Reliance Naval as well, and Syntex. There are many companies which were being traded. So we need to understand here that on the commencement of CIRP, as I explained last time also, there is no obligation, or I would say a right also with the stock exchange that they can suspend the trading. So we need to understand the background here. There are two scenarios. In the first scenario, if stock exchange finds that the company previously also has been non-compliant in LODR compliances, they will suspend the trading because of that. not for the commencement of CIRP. That specifically is written in a judgment which we discussed earlier as well. So the issue at hand is that if the compliance is done, there is a possibility of revocation post the resolution plan is approved by COC also, and they can apply for listing as well, again, once it is approved. So there is no issue with respect to trading, and there are various surveillance measures given by NSE and BSE as to how the trading will happen in a week. So that why it is given, because the manipulation must not happen. And the Securities Appellate Tribunal in the same matter said clearly that the stock exchange needs to give an opportunity of being heard as well to the respective company before suspension also. So they can put across all their points as to what was the issue and how in a reasonable time they can resolve these non-compliances and become a compliant company.
So in case you see, in fact, I have brought this specific slide on the screen. These are the Annexure 1 and Annexure 2 of the circular dated January 22, which actually provided the criteria for suspension of trading in shares of the listed companies. So what you are saying is that the listing, the trading does not get suspended because of the commencement of CIRP. Trading gets suspended because of the non-compliances of these regulations.
Yes.
So should I read these regulations, and wherever you would like to give anything which you can immediately, you can stop me. I'm only saying because since we are talking about the suspension of trading, so this particular Annexure 1 and Annexure 2 of the circular dated 22nd of January 2022, this actually provides all the circumstances where the trading of a company would be suspended. Now, this is one starting from the regulation 17.1. When I'm saying regulation, that means SEBI LODR regulations 2005 as amended from time to time. That is what I'm saying today, regulations. I'm not saying regulations like CIRP regulations or liquidation regulations. So I'm clarifying that the regulation 17.1 of SEBI LODR regulations, which is with respect to the broad board composition where the woman director has to be appointed for in case the woman director is not appointed for 2 consecutive quarters, then the trading would be suspended. Then regulation 18.1 with respect to the constitution of audit committee for 2 consecutive quarters. Regulation 27 with respect to submission. Yes, please.
So
yeah. Yes, please.
If you could allow, we can, we have also prepared a PPT as we shared last time.
Yes,
so,
yes.
Shivam can share that PPT of CIRP listing and delisting, and then we can both ponder upon the same PPT that has more robust points pursuant to our discussions with the SEBI officials.
So we can have that. We can have this.
Shivam, you can put up that PPT also.
For the delisting?
Yeah, the last PPT of part 1, wherein we covered trading during CIRP, suspension by stock exchanges and SEBI also.
Okay. So can you allow me to share the screen?
It's already allowed.
It should start working now.
Okay.
Yeah, can you see our screen?
Yes, yes.
Sure, not this one, the one which covers trading and suspension.
Okay, just a second.
In the meantime, Ankit, can we take any question?
Yeah.
So the minimum public shareholding for companies under CIRP with the 25% norms to be achieved within 3 years. That's a question from Arun Srivastava ji. I think we talked about it that
Yeah,
when a company passes a resolution plan which talks about the company's shares continuing to remain listed, then the company has to remain a minimum 5% float, which it then needs to increase to 25% over the next 3 years, right? Is that accurate?
that's absolutely correct. It needs to achieve 25% by way of various instruments. It can be or issues which can be FPOs or rights issues. It can follow or OFS also. And
Sale of shares on the market by the
yes,
promoters, something like that.
OFS,
Yeah.
yes, that's
OFS.
also allowed. And they can also they also need to comply with 10% shareholding of public within next 12 months as well, in order to pave path for the upcoming 3 years.
So to
This-
remain listed on the stock exchange, minimum 5% is required of public shareholding. At least if there's less than 5% of public shareholding, then the company will have to get delisted. If the company is having at least 5% public shareholding, then it can continue to be listed, and it has to grow the public shareholding to 10% within next 12 months and to 25% within next 3 years.
And this is the same issue because of which Ruchi Soya had to come up with 4,300 crore worth of FPO to comply with the 25% MPS.
Now, I have a very specific question here, Sumitji. One, that in a resolution plan, if I say that as far as the public shareholding is concerned, public shareholding will be reduced to a particular extent, so that finally it remains 5% of the total share capital of the company, and all other existing share capital, which may be promoters companies, promoters associate companies, all financial institutions, all those shares will be transferred to the nominees of successful resolution applicant at zero value. Is it permitted by SEBI that other than public shareholding, you can transfer all the shares at zero value? Is it really permitted?
Sir, I'll tell you. So we were discussing this a day back only. SEBI has recently come up with a consultation paper.
Yes.
Shivam, you can put that slide in relation to the consultation paper for the protection of public and small shareholders. So what is happening is that this is called on November 10, 2022, they have come up with the proposed delisting framework, wherein in order to, as per the various outcomes and the representations filed by various stakeholders and professionals like you and us, they are proposing to create a framework under the delisting regulations only, in a manner for the protection of the public shareholders and small shareholders also. And yes, once that amendment comes, all these all these promoters, KMPs and director shares will be extinguished at zero value without any compliance under the delisting regulations also. Shivam, if you have that slide, you can show it as well.
So this is slightly different. Like my specific question is, like, I don't want to delist the company. I'm a successful resolution applicant and the company's present share capital is 300 crore and the public shareholding is 100 crores. So in that case, I just want to make a resolution plan as a successful resolution applicant that my capital structure would be that all the public shareholding would be reduced to 5%. All existing share capital of the non-public would be transferred to me at zero value. My additional share capital, which I will be contributing at face value, would be this much. And the total share capital again of the company would be 300 crore and the public shareholding will be 5%, means 15 crore of that particular total share capital. Because see what I said, that the 100 crore will get reduced to 15 crore and the other 200 crore will be transferred to SRA, and the additional capital of 85 crores will be brought in by the new management,
Yeah.
That means we continue to be with 300, public shareholding reduces to 5%. And as far as the new management is concerned, new promoters are concerned, they are having total 285 crores of share capital with 85 as fresh capital and 200 as transferred capital at zero value. This is a scenario that I am really discussing with you. Is it really possible?
Yes, this is absolutely possible. So this will be like a pseudo selective capital reduction, and this will also form transfer at zero value pursuant to SEBI order and confirmation by the stock exchange also. So they won't object to it.
So, because see, like the IBC provides that no shareholders approval is required.
Yes, that's correct.
And but then you feel that the SEBI and stock exchange approval is required for transferring it at zero value.
Yeah, so they won't be able to object to it if it is approved by the NCLT. That is absolutely clear.
But don't you think that this is the best structuring if someone can understand this?
This is indeed very good, sir, that if because see, the issue is for NSE and BSE, it is still at nascent stage and they are learning every day through court orders as well and through SEBI amendments also. So as you asked in the first webinar, that whether suspension can be done on commencement of suspension is being done by stock exchanges on commencement of CIRP. So I clarified that no, it is not the case. So for them also, they are learning every day through professionals like us that it will not hamper the company and this is only an interim issue which will happen. And once the resolution applicant successfully is approved, then it can also continue as a listed company. So these are the parts they also learn and then it happens.
Yes, I think you were continuing with the suspension regulations. That is the reason that you actually opened your VPT.
Yeah.
So which
Sure,
particular
you can
slide
take up the suspension part.
In the meantime, Ankit, in case there is any specific question, because the questions are very important that we are, this is what we were reading. I was also reading regulation 17, 18, 20. Yes, please go through that.
Yeah, so Rajni is just asking for CIRP listed companies that require to disclose all notices and agenda of COC meetings. So that's a question from her.
That we already have said in our today's webinar only that yes, the resolution professional is supposed to disclose the prior or post facto meetings of committee of creditors, agenda, and also the minutes.
Yeah.
Sir, I'll also throw some light on the same which Mr. Rajni has asked, as in why it is required. And see, in case of CIRP, in order to ensure transparency, SEBI through LODR has said that there won't be any materiality or specific provisions will apply except the commercial aspects of the resolution plan or the trade secrets or how the resolution applicant will be running or proposing to run the company post successful approval by the COC. Everything needs to be disclosed to the stock exchanges for a transparent and robust dissemination of information about the CIRP process by the resolution professional. So without application of brain to specific information, he or she must or the firm must disclose to the public or general stakeholders as to what is the what is going on in the CIRP process. Yeah, Shivam, you may continue.
Yeah, for the suspension of trading during the CIRP period, as we discussed earlier, that there are certain preconditions for which the stock exchange can terminate the trading and accordingly take an action. So there are certain grounds prescribed by SEBI under the SOP, wherein they have issued one annexure was issued for penalizing the companies who were non-compliant and imposing penalty for non-compliance of LODR. And the another annexure quoted certain instances wherein the trading can be terminated during the CIRP procedure. So it is important to note that regulation 7, if the company fails to comply with regulation 17.1, which respect to the board composition, including appointment of woman director for 2 consecutive quarters, then the trading can be suspended. Now the issue here is, since we know that all the powers of the board are vested with the IRP. So how the company would comply with this regulation 17? So under the LODR, the exemption has been given to the company for not complying with regulation 17. So even if the company is non-compliant for under regulation 17 for during the period of CIRP, then the trading would not be suspended. So they are similarly for regulation 18 with respect to the constitution of audit committee. So it is not required to constitute audit committee during the CIRP period. So in that case also that is exempted. But
Just to add here, the regulation which empowers the exemption to the companies under the CIRP process, as in attendees may read the regulation, is 15(2)(a) of the LODR, which empowers these exemptions to the companies going under CIRP. Shivam, please continue.
yeah, but there are certain other grounds on which the trading can be suspended, like submission of corporate governance report during the 2 consecutive quarters, submission of shareholding pattern, and the other 2 grounds are for submission of annual report. Submission of financial results for 2 consecutive quarters and submission of annual report for 2 consecutive financial years. So these are certain grounds under which the trading can be suspended by the during the CIRP by the stock exchanges. Yeah, so we can take the next topic.
So this is where the suspension is normally given for the trading of a company. Now, what I understand, Sumitji, that there is a SEBI, there is a circular which I would like to take a minute.
Correct.
And that is something that I would. Okay. So this is the NSC circular dated 9th of July 21. No, I am not showing it to you because in fact, I am not sharing. So can I share my screen?
I think it will allow multiple sharing. You can go ahead.
Okay, so multiple sharings also is possible. So like presently, I would like to just show here, because this is very important for all the insolvency professionals. This guidance note for companies undergoing CIRP, 9th July 21, National Stock Exchange. So it starts with, when this is the Annexure 1, it starts with the circular number 002 of 2018 of January 3, 2018, issued by IBBI. Now it says, first of all, it says that it is hereby directed that while acting as IRP or RP or a liquidator for a CD for a corporate person under the code, an insolvency professional shall exercise reasonable care and diligence and take all necessary steps to ensure that the corporate person undergoes any process under the code complies with the applicable laws. This is the first circular of IBBI, and then it is said that it is clarified that if a corporate person during any of the aforesaid processes under the code suffers any loss, including penalty, if any, on account of non-compliance of any provisions of the applicable laws, such loss shall not form part of the insolvency resolution process cost or liquidation process cost under the code. It is also clarified that the insolvency professional should be responsible for non-compliance of the provisions of the applicable laws if it is on account of his conduct. Accordingly, the IPs is required to ensure that the company complies with the applicable laws, including SEBI LODR regulations. Now, this circular is in fact, it has not become very like popular circular, but according to me, when it is connected with the circular 002 of January 18, and the National Stock Exchange is saying, now when Shivam was giving me this presentation of various regulations which are not applicable, So I think these are the regulations which are SEBI regulations where the exemptions have been granted. Now, in case the IP wants to continue the trading, and for continuation, what I understand is that the SEBI and the stock exchange has a process that if there is a non-compliance, then SEBI gives a notice, and SEBI also provides for the penalty to be paid. After the penalty is paid, then the suspension is not done, because for any delay, maybe there is a delay for 1 quarter, and then the SEBI will say that you pay this much of penalty. Otherwise, in the next quarter, we will suspend the trading. So that penalty. So how do you advise the insolvency professionals whether they should go for the continuation of trading, and during continuation, in case they somehow could not comply with any of the SEBI regulations, then they will be penalized. So how do you advise, like, is it really very important to continue the trading during the CIRP?
Sir, in
Exposing
fact-
exposing
Yeah.
the IP to various penalties.
So as per my view, in fact, it will be derogatory and adverse for the company to continue trading because price would be falling, and those who wish to manipulate the stock will be playing in the stock actually, because there is no material information with respect to the financials of the company is being floated or disseminated to the market. So the IRP, it's better to go for the exemption given under 15(2)(a) of the LODR and take use of the exemption and not comply with these regulations. And once the SEBI COC approves the successful resolution plan of the resolution applicant, whoever wins can go for and starts complying and file for listing or continuation of listing if he deems so. Because otherwise the stock will remain under manipulation, go for 5 paisa, 10 paisa, or a rupee being increased in the stock price. Just what I will not name the company is happening in the recent disclosures, because it will not give the true picture of the company as to how the affairs are being conducted in the company. We all have seen how trading was being done in Suzlon stock. So we all witnessed that. That's
So-
my
So like, see, we have seen various regulations and SEBI regulations where in case we don't comply with these regulations, the trading gets suspended. Then as Mr. Sumit Kochhar says that there is a regulation 15 which provides for the exemptions during CIRP. The RP should take the benefit of those exemptions, and anyway, there are something which the RP cannot comply with, even if the non-compliance started before the commencement of CIRP. So in case he tries to comply with, in case
And
he tries to,
also not practical for an IRP to comply with all these compliances. Sir, I guess you can share your view. Will it be practical for your team to ensure that reportings are being done while you are going through all the process for the resolution plan being finalized with COC and the NCLT hearings? I don't think it is possible to prepare finances and get the audit done.
no, I have a different opinion. One, that continuation of listing and keeping the company as a compliant company, it adds value for the creditors. Number two, it is also protecting the interest of the public shareholders. Number three, it is very easy for a particular IP to appoint a consultant with the approval of the COC who will comply with all the requirements. Even otherwise, during the CIRP, as an RP, I am supposed to make the books of account, prepare the financial statements, get it audited, have an annual general meeting, get it adopted, and also file my all documents before ROC, and then similarly, I can also file before the SEBI. So accordingly, like, it is not one law which can be separated. If I'm not doing, then I'm not complying with many laws. Like then I need to comply with the income tax law. I have to file my returns of income. I need to comply with the TDS, I have to comply with the GST, I have to comply with the ROC. So all these law are connected. Then why to leave one requirement, which is a SEBI requirement or stock exchange requirement? So I would advise that if it is practically possible, now the law has completely been kind of evolved. So exemptions have
That is
been
the
done.
issue, sir. It's practically not possible for an IRP to comply with all these laws while being facing all these resolution related and NCLT proceeding related issues. So what as in my recommend to a regulator would be that especially the MCA and SEBI can come up with joint regulations as to how in case of listed entities these compliances needs to be done, or some panel say or experts can be appointed that these are the companies or consultants which can be appointed for compliance with these regulations, so that there is no additional burden or casting any responsibility on the IRP, because IRP will not be able to ensure the correctness of these disclosures and documents. You
No,
are
I think,
rightly saying
no,
about the
see, like,
consultant.
what I'm saying is that the even for income tax, see, like let us understand what is the structure of an insolvency professional. The insolvency professional can be an engineer, he can be a management expert, he can be a company secretary, he can be a cost accountant, he can be a lawyer, he can be a chartered accountant. So no committee of creditor can expect that he would be a specialist of income tax, ROC,
Absolutely.
or even SEBI, or even auditor, or even accounts. So the COC will have to allow him different consultants and will have to approve the fee for different consultants. So basically the job of the insolvency professional is to coordinate between all the agencies, accountant, auditor, the income tax consultant, company law consultant, SEBI consultant, and he has to get all these things compliant. Basically, the IRP is basically becoming the CEO of the company, as even the MCA is now giving a designation of CEO.
Yeah.
MCA has given the designation of CEO to the IRP and the RP. So
He is pseudo CEO only, sir. Absolutely,
yes.
because he's running all the departments together and ensuring viability and running the company as a going concern once the resolution plan is approved.
Absolutely. So I think we all should collectively say that the insolvency professionals who are appointed as IRP and the RP, or even the liquidator, they should comply with the SEBI regulations and stock exchange requirements. Because in case they would do that, one, they are avoiding the penalty which can actually come on their own personal head, and that can actually be much more than the fee which are nowadays being paid. So therefore, the compliances has to be done. It would be really good for all of us to make this public, that the compliances are not very difficult. We would like to appoint some company secretaries who have specialization over this, and they would comply with all the requirements. So, Ankit, what do you say?
One more small addition, that I think we have got so many people who have shared their interest that they are willing to do a reverse merger with a with a company which is under insolvency through a CIRP process. And there's a market for this because it does open the listed market very quickly for an entity which is wanting to list itself. What we have seen happen in Ruchi Soya, where there is a reverse merger, and Ruchi Soya or other the promoters have been able to recover or rather make a lot of money through reviving the unit and then creating that public float. I think that's something which maybe will be a dream for many people. So as long as you can you can actually reconstruct the asset, you can actually behave as an ARC by acquiring a unit, making it feasible, and then using its listing status to even fund the company when the company becomes better. Because we've seen that a lot of projects go bad because of a vicious circle, which is normally involved where the company is not able to deliver because it has lack of funds, and then trust is lost because of which further funds are also not available. So you can break that cycle through the listing status also. And yes, I think compliances are important, and it is maybe RP can continue pushing the COC to fund the compliance requirement of a company, whether it's SEBI compliances, Companies Act compliances, and so on. That's something that I think there is no doubt that that is an important process.
So, Sumit, in case we again go back to this NSC and BSC circular, which is on 9th of July 2021, which is a kind of guidance note for companies under CIRP. So in case you see the crux of this particular circular, it says that the disclosure of approval of resolution plan to be made to the exchange on oral pronouncement or otherwise of the order on immediate basis and not later than 30 minutes. Now, let us understand that the resolution plan is being discussed in court. And finally, the court says that without making any uttering about whether the resolution plan being accepted or it is being rejected, the court says that the order is reserved. But I understand this requirement of not later than 30 minutes, it only comes when the order gets pronounced, not before that. Not before that. So in case the order gets pronounced, then only the requirement of 30 minutes starts.
Gets triggered, yes.
Yeah. And why it is important? Why it is important? Because most of the resolution plans will have very, very sensitive information, which will immediately impact on the value of shareholders. Now, what are the possible impact on the existing shareholders? There are proposals in the resolution plans that they would get the delisting done, which is allowed under the SEBI. So that would immediately impact. If a resolution plan is approved, that means immediately the shares will get delisted. So that information has to reach stock exchange within 30 minutes. Then second, in case there are substantial reduction in the public shareholding, that information also gets approved with the approval of a resolution plan, and that also information must go to the stock exchanges within 30 minutes. Then in case the shares are extinguished, then also it is very sensitive. Shares are cancelled, it is very, very like kind of preference shares or equity shares or debentures, anything, whatever is provided in the capital structure for in a resolution plan, that is something which is very sensitive, price sensitive. This is called price sensitive.
Price sensitive information, yes. Price
sensitive information. So it has to go to SEBI within 30 days of the approval of resolution plan. So therefore, this particular failure to submit information, these are all in case we don't do that. Now think of a situation that any RP is not able to do that. Now this responsibility, like suppose as on the date of the approval of resolution plan, when the resolution plan is approved, the RP immediately demit the office. So the responsibility of giving this information, is it on the RP? Because the resolution plan has been approved, and within the resolution plan, the RP demits office, or it gets shifted to the monitoring committee. That's another question. Accordingly, I will say that the RP's duty is to continue to inform to the SEBI, even if he is demitting office.
Yes,
but he has to send this information to SEBI that this has been done. So there are kind of this is also very important. Like this is not this part, but then I'm saying the other part. In the meantime, Ankit, you can see in case there is any other question.
No question in the question box per se. But then I believe
see, we would like to see in case Shivam or Sumit can see like this particular screen, or they can also share their own screen. Is it possible that the suspension has been done before the commencement of CIRP, suspension of trading? Is it possible and practically viable for the RP to apply for revocation of suspension, and whether that actually can be done without any penalty? And if that penalty is applicable, then like I think some kind of because like I still have a question in my mind and in many of my friends' mind whether we should apply for revocation of suspension. When we
I'll answer
apply.
that, sir. Yes, so as I shared earlier, that SAT also says that you can file a representation to the stock exchanges for not levying penalty considering the company is going under CIRP.
Right.
So what can be done is by filing a representation and showing actual reasons or the evidence behind it that there was actually no one there to comply with the LODR regulations, the stock exchanges might take on record and allow that there won't be any levy of penalty or fines on the company for the non-compliances if the stock exchange is satisfied. And they can also file a representation in a manner that in the reasonable time, the resolution professional will comply with these non-compliances and also file for a revocation of suspension as well. But
However,
there
the company
will
will
be a
continue.
responsibility on the resolution professional that he'll be required to continually comply with these regulations.
Yes.
So that's another practical difficulty as per me.
So like if you are into the stock market scenario, what is the kind of costing nowadays for getting a company listed? So for example, for a company which has got a capital of 100 crore, so what is the cost of getting it listed approximately?
It's a cost in terms of as in our fees, stock exchange fees, or what?
Everybody, everyone, total process. Like today, in case I decide I have a company with 100 crores of
And analysis direction is that what kind of expense does a company save by getting a listing status through the CIRP process? I think that's the question. That overall, what kind of costing is saved?
It will cost you, say, I would say, even if you go for a reverse merger, it will cost you, say, maximum 20 to 30 lakhs in terms of if you go for this reverse merger scenario, rather than going for a main board listing where you have to go for road shows also, you have to do due diligences, prepare information memorandums, such detailed, hire various bankers. Here you don't need to hire any bankers, go for any meets. It will be a straight listing through reverse merger, and you obviously get immunity from various issues which the CIRP company was facing.
So normally, like this is a reverse merger scenario. What would be the otherwise cost of a public issue nowadays in India?
So it will cost you somewhere around 4 to 5 crores in terms of all the costings for raising capital also and complying with various regulations, hiring merchant bankers, certifications. Here, there is nothing required.
Right.
So it's
right.
obviously beneficial.
So these are some of the requirements which are on this slide, which in case anyone would like to get the suspension revoked, then these are the requirements that the execution of new uniform listing agreements, compliance of 4 consecutive previous quarters, compliance with all the LODR, and then no outstanding stock exchange dues, no pending investor complaint, no complaints pending in scores, no SEBI order debarring the company or the promoters, no difference in issuing issue of listed capital, no adverse comment on the website of watchoutinvestors.com, and should not be a vanishing company as per the list available with MCAs, signing with the depositories, payment of annual listing fee, revocation, processing fee, and the other installments of fee, lock-in of entire promoter shareholding, information memorandum, site visit of inspection of registered office, change in number of holding of the promoters and the promoters group. So these are some of the requirements for any kind of revocation of suspension. So in case any insolvency professional in his capacity as RP would try to get the suspension revoked, he would see first of all whether he would be able to comply with all these requirements, and then only he can get the trading resumed. Is that correct, Sumiji?
Yes, that's very that's absolutely quintessential, and there is a huge format which is given by NSE and BSE, which one needs to comply. And certifications are also part of this revocation process, sir. And it is almost quite a huge process wherein They call for understanding also and various documentations and clarifications during the confirmation of the revocation process before they finally approve it.
So this is a scenario which is on the screen, like if a listed company goes through CIRP, and there are two scenarios. One is the CIRP is successful or the liquidation order is passed. Now, in case the CIRP is successful, then we have to look into the resolution plan. In case the resolution plan says that the entire share equity capital is reduced, cancelled, or extinguished without any payment to the existing equity shareholders, then the company is delisted. However, in case the successful resolution applicant wants to continue the listing of the company, he would have to make a resolution plan which is fully compliant to the SEBI regulations. Otherwise, the company will get delisted. So this is a very, very important information to all the insolvency professionals, all the resolution applicants, that the resolution plan must be compliant to SEBI laws. Now, the second is like an exit opportunity to the existing shareholders is provided, wherein the minimum liquidation value is paid to them. No, in some companies, even the liquidation value is payable to shareholders. Some companies. There may be some real estate companies where the value is very high, but it is only the fund flow is blocked. Therefore, the company has gone into insolvency. And in those companies, I still believe that there is a value for the shareholders. So their minimum liquidation value can be paid to them. Then the company is subsequently listed post the approval of the resolution plan. But in case the company gets listed post the approval of the resolution plan, then the entity may be permitted to continue as a listed only if 5% of the fully diluted capital structure. Now, when I was giving you example of this 300 crore company, was I referring to fully diluted capital structure of the company, Sumit? Because I said the existing capital 300 crore, public shareholding reduced to 5%. So that was again a scenario that 5% of the fully diluted capital structure. That means after reduction, after the new shareholding from the promoters, then it should be 5% or 25% within the next 3 years. So all these are the requirements. Now, what we are trying to say, yes, as far as the guidance to the insolvency professionals are concerned, one, that for a listed company, everyone should try to continue the trading of the company. This adds value, and you can do it. You have to comply with it, and it is not an option. In case the company is a listed company and a trading company as on the date of CIRP, it is not a choice. The IRP and the RP has to continue the compliances. Otherwise, any penalty will have to be paid from his own personal pocket and not from the CIRP cost. Second, a resolution applicant should prepare a resolution plan completely focused whether he would like to have a company continued as a listed company or not. In fact, there is a stock exchange guidelines regarding delisting of the company, and those guidelines are not applicable to companies under insolvency. If a company is under insolvency and it is proposed in the resolution plan that it will be delisted and no liquidation value is due to the shareholders, then it will be immediately allowed to be delisted. That is something which is provided in the regulations.
That's correct.
So these are the two things, one for the insolvency professional, the other for the resolution applicants. So these are the two very, very important discussions that we wanted to do. And anything that you would like to add when the liquidation order is passed?
So in terms of when the liquidation order is passed, so it's a very kind of a bad scenario for the shareholders, those who have been invested in the company, and it is left to the fate whether they will get anything from that process or not, because there are various regulators also and other creditors, because of which this recent framework which is being proposed by SEBI is being done, that they will take care of a scenario as per the comments received from the industry as to how they will protect small and public shareholders in case of a liquidation order is passed, which has no, option of giving anything to these small and public shareholders. So that will be decided. I guess it is about to come up in first week of May or end of May. SEBI should come up with it.
So like my understanding is that whenever a liquidation order is passed, it also does not mean that immediately the shares will get delisted. It will not mean. Secondly, I also would like to say that Section 28 of IBC says that for any change in the ownership of the company, the COC approval is required. So therefore, for a listed company, normal transfer of shares, which earlier used to be approved by the committee of by the board of directors, now will have to be approved by the committee of creditors rather than board of directors. So all these decisions are supposed to be taken by the committee of creditors instead of board of directors. Therefore, it is very, very obvious that the lawmakers were very, very conscious that the listing of the company and the trading of the company would continue, and the powers were shifted from the board of directors to committee of creditors for transfer of shares even in the normal course of trading in the stock exchanges. And any promoter's shares also would transferring to other third parties also would immediately, we would require COC approval, and the COC will never give this approval. Whenever COC is giving approval, because I handled this part in the LML Limited, whenever the COC was giving approval, it was very careful that under Section 28, the COC was declining all those third-party transfers of promoter shares, but the COC was giving approval to a normal public shareholding transfers from one person to the other person. So, and in liquidation, the company, I believe immediately the trading gets suspended, but the trading gets suspended, but it doesn't get delisted. The shares only gets delisted when it is concluded that there is nothing which is being payable to the company.
Yes,
and there is no liquidation value.
The basic premise behind that is that if there is a possibility of giving anything to the shareholders, so the suspension as a first step so that there is no stock manipulation or unnecessary loss to minority or public shareholders is there because of drop of stock price because of the liquidation order. So what happens is that maybe in case of delisting, then maybe an exit price being given or the residual value price being given to those shareholders which are still on the company. So that may be a possibility in various companies by, say, sale of assets or any other recovery which is being done post the approval or passing of the liquidation order.
And especially when we see that there is a provision of sale of a company as a going concern during liquidation process. So we have sold recently a company which is a listed company, and all certain applications are being made to SEBI for revocation of the suspension of the trading and for continuation of the listing, even when the company is being sold as a going concern during liquidation process. So I think we have concluded various things. One, the RP should continue all the compliances. In case he can continue the trading, that would really be advantageous. And it is not an option. It is an obligation on him. And in case of any penalty, it will be paid from his own pocket.
Yeah.
He can try for revocation of suspension in case the suspension has been done prior to the CIRP. But as Sumitji said, that in case the COC agrees for all the expenditure, and in case the COC agrees to pay the penalties of the stock exchange.
I'll add one line here, sir. Sorry to interrupt you. Why IRPs, this is my personal experience, why IRPs don't go for any compliance or continuation of trading in most cases in India is because, as you rightly point out, it goes from their own pocket if there is a non-compliance. On the other hand, if we see overseas, especially in UK and US, in case of resolution professionals or insolvency experts, they get insurance and the liability doesn't come on them because of various options available, that if there is a non-compliance, then also they can opt for DNO policies, which will not put liability on them at a later stage, which is why they are more scared. And our law doesn't cover all those possibilities because there can be either a miss or impracticality of compliance also.
But still, we need, there is a space for a consultant in the market
Absolutely.
who can specialize to handle the listed companies during CIRP or during liquidation. And this is a really a beneficial thing. And the resolution applicant will definitely get a good benefit in case he's really trying to get a company,
Revive the company.
not only for real estate, but for real business. So I think
So let me
Yes.
quickly ask a few questions on the Q&A. I think it will not take more than 5 minutes to quickly answer them. So the first question is, what is the penalty if the company should not be able to garner the 25% public shareholding within 3 years? That's Ranjanji asking this question.
Sumit, you answer this question.
Should
Yeah.
I answer this question?
Yeah, Shivam, you can answer.
So basically, there is one SEBI circular in 2017 in October. So wherein they have granted power to stock exchanges to levy fines on the companies who are non-compliant with the minimum public shareholding norms. So if they continue to remain non-compliant, say after in the resolution plan, they have written that 5% will remain listed on the stock exchange, and the remaining will be brought down to 10% in next 12 months and to 25% in next 3 years. But if they fails to brought the public shareholding to 10%, in that case, the stock exchanges have the power to levy a fine of 5,000 per day till the time the company remain non-compliant. Along with that, they will take action against the promoter and promoter group by freezing the secure demat account. They will not be able to trade in any securities of the company. And the third would be two. So third will be the just a second. There's one more power to stock exchanges wherein they can, yeah. So the promoter and promoter group will not be appointed as a director in any other listed company till the time they are non-compliant. So these are the three main powers. And if they remain non-compliant till 1 year, the penalty of 5,000 will increase to 10,000 per day.
Right, right. Yes.
So
Ankit.
great. So the next question is, when erstwhile directors are not supporting the resolution professional in sharing in financial accounting, shareholding pattern, etc., what is the remedy that the RP has to comply with NSE and BSE? So I believe that, as we discussed earlier, the RP has to make a best effort to collect the information from whatever other sources are available if directors are not supporting, and there, in case the bank statements are available for the banks, the accounts can be prepared using the understanding of the management. In case it is a going concern, it becomes anyways an obligation for the company to prepare books of accounts to comply with GST, other compliances to remain a going concern. So using which these compliances can be done. Induji is asking that in case I say I'm a shareholder in a company and the company which I'm a shareholder of goes into NCLT under IBC, then how will I get informed about the fact that it has gone into IBC? So there I believe we understand that INC 28 is filed whenever a company goes into insolvency. IBBI, you can always do a public search, find what companies are under insolvency. And lastly, the most important is that there's an obligation for reporting to the NSE and the BSE as well, that the company's CRP status, what is it, has the company gone into CRP? There is a requirement for the company to make a public announcement about it. So yeah, maybe you can add something.
Yeah, Ankit, I'll just add something here. So, Induji, whenever you search for a particular stock, say right now you can go on BSE, and if Shivam, you can just share the screen and show how it works. You can see Reliance Naval. So Reliance Naval, you will see at what stage of IBC it is, and you can
Just share your screen first, then I think we'll search.
Yeah. So what happens is, whatever stock you own, say if at one point in time you used to own Ruchi Soya, so you can Google, go on BSE website, search Ruchi Soya, and it will show how the BSE surveillance measure works and which stage of IBC it is and how your stock will be traded, whether it is under IBC 1 or IBC 2. That will give you a better idea.
So this is the BSE website wherein the company shares are being shown, and therein you can see the corporate announcements here and go to. So these are the disclosures which they are filing, and there are CIRP updates which they are filing.
Just check this company called Future Supply Chain.
Future supply chain.
Yes.
Check in that same BSc tab only, no?
Yeah, just a second. So
So is it suspended training?
Yes, if you see here, Induji, you can see IRP stage 1. So this will give you on account of IBC, recommencement post IBC. Once they apply for it, so trading is restricted right now. So this is how you can assess that if you own a stock, you will understand how this works. And if you go down, Shivam, you will see various corporate announcements. So under these corporate announcements, you will see that how they are promptly, or the IRP is promptly intimating everything. You can click on any of this, say invitation of expression of interest. So you can click on this PDF and see the form G which they have floated. So this will give you entire information, and without any application of materiality, they just need to disclose each and every information and all the aspects pertaining to the CIRP process.
Any other question, Ankit?
I think that's it.
Then we can stop sharing for the time being and just say
Yes.
bye to audience. So I think this was really we were able to conclude many questions which were actually in our mind when we say our most of our audience ourselves. And thank you very much, Sumit Pocharji. Thank you very much, Shivam, and thank you, Ankit, for helping us, and also the lot of research which has been done by the team. And I would also thank Shivam for the research, and my team, Advocate Amar Vivek has also done some part. So thank you very much, and this webinar is concluded. Thanks a lot.
Thank
Thank
you,
you.
everyone. See you
Bye.
next week. Thank you.
Thank you.